Hey everyone, Happy New Year. This is an update on the Jared Leisek case. As many of you know, he had his preliminary hearing finally. Many of us were actually really believed that it was going to happen, and it did on the 29th of December, so last Friday. And in that, I did a short, very, very short video on what happened on that. And I'm going to go through that again today. But many of you emailed me, and I actually happened to find this while I was on vacation, the video that Profiling Evil, his name is Mike, and he is a former police officer. He actually attended the preliminary hearing, which was in person. So there was not a WebEx link. We couldn't attend virtually. So he actually drove to the hearing and attended the hearing and gave a recap of what happened during the hearing. So in this video, what I'm going to do is start off with some of the documents that have been filed. So we're going to go through that. That's new information. And then I'm going to recap, give a summary of what Mike said in his video of what happened. He was the only person, according to him, that attended that in-person meeting. Obviously, other than, the defense and the prosecutors and the clerks and all that stuff. So all those people, but nobody else was in attendance. So basically, he's the only account of what happened. So I'm going to share what he said happened and give some additional thoughts. Also, full disclosure, I'm not going to be editing this video, so I apologize in advance if it's a little clunky. And so really, really appreciate all of you. I wish you a beautiful, wonderful, happy new year. If you haven't yet subscribed to my channel, please do. We strive to be a voice for the voiceless, missing persons, survivors, and those who need our support. And that's why we're here. Okay, so what I wanted to start with is sharing some documents. So I was able to go into to get some of the documents that had been posted. And let me see here. What am I going to do first? Okay, so this is the ledger. And let's see if I can do this. Okay, so basically, what happened is there was the on the 29th. So usually a couple of days after they post what actually happened, right? And then also they will also post the next upcoming hearings or anything that's scheduled related to the case. And so on Friday, there's a description of what happened. But this is the part that really alerted me. So before I do any of my videos, I always check the ledger just to see what has been posted. Are there new documents that have been filed? Is there anything new that comes up? Because I want to make sure that I provide the latest updated information to you guys, right? I don't want to do something and then all of a sudden something else came up and and then my information is not current. So I did this, and the first thing that popped up to me and I freaked out is it said, court does not find that probable cause exists. And that just put me into a tailspin. But I reached out to the clerk and she said that that was not correct. So I was like, well, if there was no probable cause, then how come it's going to trial? Why is there a pretrial conference and all that? So I was able, it was just an error. So if you see this document, that should hopefully it was corrected in a new document, which I'll share now in a second. But if you do see this, or if anybody posts this, that is why that was incorrect. So probable cause was found, and that's why it's going to trial. And I'll read all of this little recap will be again in the other document that I'm going to share now in a moment. But a pre-trial conference was scheduled for the 21st of February. And so that's going to happen. And up here, it's added in here as well. And of course, that will be with Judge Mandy Larson, who has been presiding over all of the hearings since the beginning. So I'm going to share a recap now in a second, but this was it. This was the docs that, so you see, this is the bind over order is the original document. And they just filed a new bind over order with the correction that I suggested. So I'm going to share that document with you now in a second. Okay, so that was the first little bit I wanted to share. The second thing, so this is the bind over notice. I'm not even going to show you the old bind over notice because it said what it said there, which is that there was no probable cause. And I was like, on? Like for a second, I had to really like, try to figure out what is going on. Are we in an alternate universe or what? So this is the new updated bind over notice. And sorry if I'm not happy about it. It's just that it really put me into like a strange tailspin for a bit because I couldn't believe it after all of the weekend we'd been talking about and even listening to Mike from Profiling Evil. I couldn't believe it. Anyways, so the charges, he has are of a child, as we all know, a first-degree felony, and he pled guilty, or not guilty, sorry, he pled not guilty on Friday. And it says the defendant is arraigned, and it says hearing written statements and witness testimony are submitted as probable cause at the preliminary hearing. The court finds probable cause exists, and this matter is bound over for further prosecution. The defendant is to be held to answer to all or some of the charges listed in the information on file. Mr. Mangum, who is the prosecuting attorney, waives an opening statement. Mr. Mangum calls Devin Krebs, who is the investigator, to testify. The witness is sworn to testify. Mr. Mangum with direct examination. Mr. Mangum offers Exhibit 1. Exhibit 1 is received. Mr. Mangum continues with direct examination. Mr. Mangum offers Exhibit 2. Exhibit 2 is received. Down here, Mr. Williams with cross-examination, witness is excused, Mr. Mangum rests, and Mr. Williams, who is Mr. Williams and Kara Tangaro, Ms. Tangaro are the defense attorneys. So Mr. Williams reports they have no witness. Mr. Mangum with closing arguments, Mr. Williams submits, court binds matter over for all further proceedings. Ms. Caro, which I don't know who that is. That might be Ms. Tangaro, might have been a typo. That person requests the audio be protected. Court orders audio protected and to be only released to the state or the defendant or defendant's counsel. A separate WebEx link will be created for the pretrial conference. So we will be able to attend the pretrial conference, which will be once again on February 21st. So we'll be able to attend that. And so this was one thing that was kind of interesting. So, we have to pay for each of these separate documents. So I just went ahead and got also the exhibits, because there was one for that just to see, and just layering this or combining this together with, many of you have already watched Profiling Evil's account. I will recap it and I will put a link to that later. But he did say that if I had to guess, so obviously it's under seal, like we don't have it, but Exhibit 1 is the statement from the victim herself. Exhibit 2 is the statement from her mother. So that's what I'm able to gather from this. Okay, so I'll stop sharing that and I will share the exhibits. Let's see, exhibits. Here we are. So this doesn't really, this doesn't really tell you much. Okay, so number 1 was witness statement, number 2 is witness statement. So that's why I think the number 1 was the statement from the victim herself, and number 2 was a witness statement from the mother. I'm not 100% certain on that though, but I'm filling in based on what Mike from Profiling Evil said. So and he also, I remember Mike said that they didn't actually share, like they didn't read the statement. They didn't read any of the statements. They just, the person who testified, the investigator, kind of gave a recap of what was in the statements. So, so that I thought was interesting there. So those are the 3 documents I wanted to share with you. And so if anyone shares anything or any documents that says that there was no probable cause, it should be updated to the new documents that I shared with you today. Okay, so now that we got that out of the way, okay, I wanted to give you a recap of what Profiling Evil's account of the preliminary hearing was last Friday, the 29th. So first couple of disclaimers here. I've never watched Profiling Evil's account. I've never heard of him before, maybe something of his, but maybe not, I'm not consciously aware of anything that I've seen of his. So that was the first time I was consciously aware of seeing anything from him. So I don't have an opinion on him. Apparently he is a former police officer. So I didn't do any research on that on him. So I'm just going to take his word for it there. Okay. The other thing is he said very clearly right from the beginning that he is a friend of Jared Leisek. And he's worked on criminal analysis on missing persons cases with Jared Leisek. So he was doing more of the criminal analysis aspect, and Jared AWP's team was doing like the actual search for on the different cases. So that's how they know each other. And I will say this, from in my humble opinion, he tried to say that he was being maybe unbiased. I don't think he was unbiased, but certainly I think he was trying to be balanced in his account. So just like I can't say I'm unbiased because I'm clearly supporting survivors. So my angle, my focus will always be more survivor focused over, accuser or accused focused, right? I'm going to lean on one angle over the other. However, I try to present documents and give facts whenever possible to be more balanced in my view. I don't badmouth, I don't call people names like some other true crimers. Unfortunately, I think that gives a bad rap to the true crime community. But I try to stay within whatever possible neutral. So all of that to say, there was a clear bias that he has because he is a friend of Jared Leisek. That said, all right. So what he said, he was the only person who was in court other than those involved, like the defense, the prosecution, the judge, the clerks, all of those people. So he was the only other person there. He said he chatted, so he spoke with Jared Leisek before court started, which he said was just after 9 a.m. He said that there was only one witness, and that was the investigator, and that the victim was not present and did not speak. He also said that Jared did not speak. Jared Leisek did not speak, and that was probably under the advice of counsel. And which, just as an aside here, this is my opinion. I did think it was interesting that he sort of positioned it like he would have wanted the victim to speak, but didn't really, almost like that was not a good thing, but then didn't really have, made it sound like it was obvious that his counsel would advise him not to speak. So it was almost like in my, there was a little bit of a bias there against the victim it was a slight bias, but that was my opinion there. Okay. So he did say that there was a small town, it was a small town jurisdiction. He said that it may be hard to find a jury because it's a very small community. So the numbers aren't there to find a jury. And then he said that the investigator only had 1 to 2 discussions with Jared Leisek. He said he thought it was 1 by email and 1 by a cell phone call. And that the investigator, and this is the investigator on, testifying here as the witness. The investigator said that he had those 1 to 2 discussions with Leisek. He said the investigator received the allegation by email after the victim reported the crime to the Las Vegas Police Department. And it was reported there. And Jared Leisek at one point lived in Las Vegas. So he thought that maybe that's why it was there. And that last part that Jared Leisek at one point lived in Las Vegas came from Profiling Evil. That didn't come from any other source, but he said that there in his video. So let's see here. So Las Vegas said it was outside of the Nevada statute of limitations. And he said he believed the Las Vegas police encouraged, oh, I'm sorry. Let me rephrase that. So Profiling Evil, so Mike said that the investigator said that Las Vegas said it was outside of the Nevada statute of limitations. And the investigator said he believed the Las Vegas police encouraged the victim to report the crime in Utah because Utah now had removed statute of limitations on the most serious child crimes. And he requested that the Las Vegas investigators go back and re-interview and record the victim's statement and send it to him. So after listening to the recording, the investigator contacted the victim and asked for a statement of what happened in the assault, and that is what was entered into evidence in court. And so this is what I think was that statement number one. Mike from Profiling Evil said that the victim's statement was not read in court, but that the investigator did testify about what was included in the victim's statement, and that an incident occurred in a home in Sanpete County, Utah, sometime between the years of 1990 and 1992. Now, he'll say this later, and I'll just make a note here. He did say that maybe that there was something about 1993 also. And so he kept saying that would mean that Jared Leisek was a minor. The thing is that if the incident happened in 1993, depending on the dates, Jared Leisek might have been 18. So, the dates do matter here. That's a very, very close date. So if it did occur in 1993, then he could be an adult. Okay, so Mike from Profiling Evil said that it was troubling that this played out in public court because if Leisek had been accused at the time of the assault, assuming he was a minor, it would have happened in private and wouldn't have been publicized. And I do agree with that. However, my only thing with that is that that's assuming that the victim reports it right away. But there is a statute of limitations. And so what if a victim would have reported it months later after he's an adult, and now the person is an adult, right? Would this still happen? Would it still go through juvenile court? I'm not an attorney, and I'm definitely not a legal expert in Utah, so I don't know how that would have happened. So I do agree that it doesn't have to be, it wouldn't have been publicized like this, but the reality is that in cases of R, many people do not report right away. In fact, it's statistically underreported, and I'll go more into that later. But I did think that was really, I agree with him in one respect, but in another respect, there's the potential that they wouldn't have done it within the statute. If she would have reported within the statute of limitations, it would have been outside of the him being a minor, right? Hopefully you followed that. Okay, so let's see. Another thing is that he also mentioned several times that that he thought it was concerning. Mike thought that it was concerning that that he's being tried here as an adult. But I don't think that he attended the motion to dismiss hearing, in which the judge very clearly stated that if Jared Leisek is convicted, he will be sentenced as a minor. So even though he's being tried in adult court, he would be sentenced as a minor. So, most of us believe that the sentence would be far less, maybe not even have any prison time. Okay, so there was an entire section where he talks about statute of limitations. This was another concern that Mike had, and that was another case. There was actually a civil case called Mitchell versus Roberts, in which a woman claimed to be SA'd in 1981 in Utah. Then it ended up going all the way up to the Supreme Court. And what happened is that because the statute of limitations had been revived, that's why the civil case originally went through. But when it went up to the Supreme Court said that the legislature was prohibited from retroactively reviving claims that deprived the defendant of a vested statute of limitations. So in other words, you can't go back when somebody has committed a crime and then it's outside of the statute of limitations. You can't go back and change the statute of limitations and basically, I guess, instead of favorably hurting somebody, a defendant. And so he says, is that going to happen in this case? so that he brought that up. And okay, so I think that's certainly valid and definitely maybe something that will come up on appeal if this goes through and if he is convicted. Okay, so the next thing he said is that Mike said that according to the detective who was on the stand, everything that other people reported was based on things told by the victim or heard from Leisek. Not one person witnessed the events according to the detective. There were no witnesses, only the victim's statement. And one thing, here's a side note. Profiling Evil made that sound like this was an enigma. We're talking about R. Usually that is a very private incident, right? Usually there are no other witnesses. And that's typically part of the reason why it is statistically underreported, why it's so underreported, and why it's so difficult to try. So I don't know, it stood out to me a little bit that he made it sound like it was kind of a big deal that there was no other witnesses. Like, obviously, if there was somebody there watching it, then, either that person needs to be charged as well, or that person would be a witness, right? So yeah, I just thought that was kind of interesting that he made that point. Okay, so it's almost like don't we know that there weren't other witnesses there, right? I mean, anyway. Sometimes you just have to laugh, laugh at things. Even though they're not, nothing matters in this case, but it's just like consensual. That's not even a word. All right. So the next point, he also said that Mike also said that the detective in testifying said that Leisek did not confess to the crime of a child, but he did say that Leisek's email included what he termed to be admissions that molestations had occurred in the family, and the email document was not read in court. So the detective did acknowledge the emails that all of us have seen and read. And so many people, many people that I see in the comments keep saying, but he admitted to it, he admitted to it, he admitted to it, right? And Leisek admitted to it. I think he admitted to something. He just did not admit to R. He did not spell that out. So I think that it could be used, it sounds like it's being used in a sense as like to corroborate, but not as an official statement that, that he did something, an admission of sorts. So the detective also said that Leisek did not confess to the crime. Oh, sorry, I'm rereading that part. So the email document was not read in court, according to Mike from Profiling Evil. The detective admitted that the victim couldn't remember when the crime actually happened and was guessing at the years. The detective went by when the house was there in Sanpete County because apparently it had been torn down. And so he was able to go through the records and see when the physical house was there. And also the school records of when the victim lived there, so he could match up the dates. And that's where the detective placed the assault at some time between 1990 and 1993. And Mike from Profiling Evil kept saying that would mean he's a minor. However, I just need to clarify that in 1993, Leisek could have been 18, depending on the dates of when the assault would have happened. So that means he would have been not a minor, he would have been an adult. So just saying that blanket statement that because it was happened between 1990 and 1983, he would have been a minor is not correct, just because of the, that it's very close there. So depending on when it happened, if it did happen in 1993, then there's a possibility that he would be an adult. But from the beginning, all the documents I read kept on saying 1992. I remember it was said on or about January 1992, and the second incident, I believe, was October 1992. And if I'm not mistaken, Jared Leisek's birthday is in September. So that's why it kept on saying when she was 9 or 10 and he was 16 or 17, because one could have been, right before or after his birthday. Okay, so what's next here? The detective said that he had concerns about the statute of limitations, but that he left that in the hands of the prosecutor, who was also communicating with witnesses and reaching out asking for additional information. The defense tried to get the court to share that information. So the defense attorneys tried to get the court to share that information in court, but the judge said no and cited Rule 11-1102, which basically says that the reliable hearsay is admissible in preliminary hearing examinations. When the detective was asked why the statements from the victims that were favorable Leisek's defense were omitted from the filing, the investigator admitted is the word coming directly from Mike. The investigator admitted that it simply boiled down to the victim's statement with no other evidence outside of the assumption he made by Leisek's remarks in the email conversation. So that's interesting. So he's saying that the investigator based all of this on the victim statement, along with the assumption he made by Leisek's remarks in the email conversation. Okay, so here's another thing that's kind of interesting. Let's see. So even though he didn't admit to anything specifically in writing, Jared Leisek has admitted to kissing cousins stuff. He even said it in an article that came out. So, in some states, it's illegal for family members to have any type of, relations. And I don't know what the extent of kissing cousins is. Is it just kissing or is it more than kissing? I don't know. But either way, it's still grossly inappropriate, especially when you have an age disparity of that much, right? We're not talking about a couple of years or they're all young, you're all teenagers, there's a large age disparity, especially at those ages, right? Okay, so went on to say, when the defense questioned the investigator about the fact that the victim changed the dates and ages after the question came up about the statute of limitations, the detective was stopped by the judge. And I think he asked them to come up they had a sidebar, and then they stopped that line of questioning, according to Mike from Profiling Evil. The defense asked the detective if he reviewed the letters that Leisek's witnesses had provided to the prosecution that disputed the timelines and evidence, and the detective responded that the prosecution had never shared those with him and that he's never seen them. So that, when I first heard that did stand out to me. And then when I listened to it again, I said, well, the prosecution does not necessarily have to go back and share every single bit of information with the investigator, because the prosecution is doing their own investigation. So although it does sound strange that they wouldn't have shared that information, I don't necessarily think, there could be reasons why. Maybe I don't know why, but there could be reasons why. But it definitely shocked me when I first read that, because you would think that they would be sharing information with each other. Okay, so then the judge stepped in again and reminded everyone that she has one job in a preliminary hearing, and that is to determine whether there's enough evidence to find probable cause and move the case to a trial. And she said it's her job to lean in the direction of the state's favor when it comes to evidence and questions. So then the prosecutor then presented a statement from the victim's mother, and she said that Leisek apologized to her for things that happened between her daughter and all the other cousins. The statement didn't suggest that Leisek confessed to doing anything, and the word "are" never came up by any of the witness statements until the question of the statute of limitations came up. And then, according to the defense, the word "are" came into play. So the concern I have about this is that most people, when you hear about incestuous relationships, they don't say the word "are." They'll use incest, or they'll use molestation, or they'll use other words because it's traumatizing. And so sometimes, and even when you look at the legal definition of R, it's much broader than what most people think. And so there could be some overlap in terms. One person might think, it's like, we're not all like, things happen to us. Like, how am I supposed to know? Like, if I'm like assaulted battery, like, oh, I was batteried the other day. Like, I don't know. Like, people don't grow up like knowing all these specific terms, blanket terms for everything. And so I'm a little bit like using that as a defense is a little bit, and I see this all the time in my comment section, people saying, well, why didn't she say the R word from the beginning? And I was like, it's traumatizing. That's definitely, the R word in general is traumatizing. And the only reason I don't use the R word is because I want to make sure that you can see this video. So I know, like, I posted another video the other day that had a certain something and it's gotten like 20 views. So I want to make sure, I prefer to use the R word and piss off a few people or say the say R instead of the R word and piss off a few people than to have nobody watch it, right? So, all right. Next, the detective said that Leisek never admitted to R-ing the victim and never told anyone else. The state said they have no other witnesses and evidence or things to present. Okay, so sorry about that. I'm just reading off of like my notes, reading my bullet points of what happened of Profiling Evil's account. And by the way, feel free to go watch that entire thing. It was kind of long. It was over an hour. So I'm just giving recap of what happened in court. So then the detective under cross-examination said that the victim's testimony changed from the point of the recording in Las Vegas and other Metropolitan Police Department and the time when she wrote her statement when she learned that something was outside of the statute of limitations. I hope I read that correctly. How he doesn't know because it wasn't presented in court. Got it. Okay. So the detective under cross-examination said that the victim's testimony had changed from when she originally did the recording in Las Vegas and the police department and when she wrote her statement after learning about that the incident was outside of the statute of limitations. So he said, Profiling Evil said that he didn't know what the difference was because it wasn't presented in court. So he couldn't go back and be like, okay, it was because of this specific date and this specific thing and all of that. So he didn't know what that was. So then the defense said that they advised their client not to testify. And then the judge asked him if he did not want to testify, and Jared Leisek confirmed that he was not going to be testifying in the preliminary hearing. So then there was a closing statements. And all the evidence in this case, this is what Profiling Evil said. All the evidence in this case is based on the victim's statement to the detective, which indicated that she was R'd by Leisek before the age of 14. They included a statement from her mother that said that her daughter stated that the assault occurred, although it was not clear when the victim told her mother of the assault. So I just need to clarify here because he's saying that they're saying that all the evidence is the statement from the victim. But then they're also saying that there's a statement from the mother that her daughter stated that the assault occurred. So that's another statement as well. So there's two statements that they can use, not just one statement, there's two statements. The defense made no closing argument. And then the judge quickly ruled that there was enough probable cause to bind Leisek over for trial, charging him with R of a child. The judge also ruled that audio and written transcripts from the preliminary hearing would be sealed from public release. At the defendant's request, the judge allowed Leisek to waive his arraignment on the charge, and he entered a not guilty plea on the spot. And then Profiling Evil said again, there was only one eyewitness victim in this case, but he's not acknowledging that this is precisely the difficulty. This is my thoughts. He's not acknowledging that this is precisely the reason why it's difficult to try our cases. They're underreported, largely underreported compared to other violent crimes. And also why statistically, only about 4% of people charged, convicted with R even go to prison. So, it's hard to try. It's not reported. It's hard to try. And then very, very few actually go, like only 4% go to prison and those are the most terrible, awful cases. And so he also said that the email may be an admission of sorts, but not a confession. And that's what I think too. I see the email, that was a statement coming from Mike. I also do think that he is admitting to something, but he's not confessing to R. So he's admitting to something, to some wrongdoing in those emails. That's what I think. But he didn't spell it out, right? So it is not a confession. So I do agree with that. So another thing he said, he also went on, Mike from Profiling Evil went on to discuss false memories. And so this was part of the reason he brought this up, to suggest his concerns with a single piece of evidence, and that single piece of evidence being from one person's memory. So even though there was a second statement from the mother, that's based on the first witness's memory. My concern with him bringing that up is that there's so few false allegations that's concerning for me. So I try to empower survivors. And this is, when people bring up false allegations, and so many people only bring up false allegations when it comes to R and SA. It's like, it's so underreported, and yet people always think it's about money, or they think that there's all these other things, and rarely is it about that. And in fact, only about 4 to 5% of allegations of any crime are false, including R and SA. And in the case of R and SA, a lot of times it has to do with like kids or teenagers who don't want to get in trouble. So they might like make up a story, and they're not the ones going to reporting it. Sometimes it's the parents. A lot of times it's the parents reporting the person. And so it ends up being a false report because the kid lied to the parent. Well, that's very common. Are there people who make false allegations? Yes. Are there people that have false memories? Of course, especially 20, 30 years ago. Yes, of course. But when you're talking about a family member, I mean, I could see a false memory about, like, I don't know, if you're at a place where you don't really know the person. Like if you're a little kid and you're like at sleepaway camp or something like that, or if you were at a church, or it was something like a janitor or something like that, that you don't really know the person. But I really find it hard to think that a child would, especially 9 or 10 years old, would have a false memory about a family member that they know well, right? So that, I just think that there are circumstances. So anyways, I'm not saying it didn't happen, or that couldn't happen. It's just that sometimes, it makes less sense to me that there would be false memory about something like that over in an incident where it was somebody that they didn't really know very well. Okay, and he kept also saying that he was concerned, this is Profiling Evil, that he was concerned that Jared would be sentenced under adult rules, but the judge has already specified in the motion to dismiss hearing that he'll be sentenced as a minor if he is convicted. So, I mean, this is like, it's going to trial, and so there needs to be enough evidence to, to convict him, and there hasn't been that much evidence presented in the preliminary hearing. In fact, as we've already stated, it's really basically three pieces of writing: a victim statement, the statement from the mother saying that the victim told her that the assault happened, and emails, which don't have, as we've already said, don't spell out a confession, but they admit to something, they admit to some wrongdoing, but they don't have a specific confession to this specific incident. So yeah, it's interesting. So definitely a lot less evidence than in most cases, you have to have something, but or let me clarify that. You have to have, typically there needs to be probable cause, sufficient probable cause in a preliminary hearing to go to trial. In this case, the judge believes that those three pieces that were discussed are sufficient to go to trial. So it would be really interesting to see. I do see and understand why people keep telling me in my comments that there isn't enough probable cause, but also people are using that in the comments to talk about why he isn't guilty. And we have to remember that this has always been a difficult uh, case to try, because nobody was there. There isn't any eyewitness. There isn't any evidence. There wasn't an R kit done at the time, right? So there is a lack of evidence. And so this is always going to be, but just because that happens doesn't mean that he isn't guilty. And I'm not just talking about him, I'm talking about all R cases. This is why only 4% of people who commit R go to prison. So if we go in with the assumption that I like to say, like, I don't 100% know either way. I just think that just based on statistics, it's most likely that this happened. Is it possible that there was a false memory? Yes. Is it possible that these are false allegations because they're making it false allegations? Yes. Is that likely? No. Why? Because of statistics. So, of course, anything is possible, and we'll have to find out more information in the coming months after the pretrial conference and when the trial is set. But for now, that's the account of profiling eval who attended the preliminary hearing. Again, I'm obviously not unbiased, but I hope that this gave some additional information. I'm sure many of you don't agree with me, and that's fine. But again, I'm always going to try to defend, or at least empower, survivors, because why am I going to talk about the potential of, false allegations and all that when it's statistically underreported? I'm referring to R and SA. It's statistically underreported. So why do I want to make it harder for people to report R and SA, right? If anything, I want to empower them to not only report it, but also understand and be more aware so that we can prevent it from happening. And so that when people tell it to us, we can believe them and we can support them, and maybe give them tools to empower themselves, maybe to prevent in many cases. What can we do to prevent it? So anyways, and especially when you're talking about R of a child, this is why this is particularly important, because this is such a vulnerable group. Children don't know what's happening to them. They're not taught they don't understand. And then many people just don't report it. They simply do not report it. And that's why the statute of limitations on child R have been waived in many states, because it does sometimes take a decade or 2 decades or more to come out and report it. And more so when it's family, right? Like, how awkward and awful is that to have to go through that, right? And then unfortunately, the victims are the ones who are made bad, made wrong, instead of the people who should be made wrong, right? The ones who should be held accountable and held responsible. So that's my little soapbox for right now. Thank you for entertaining me, entertaining my, my little mini rant there. But I hope that you learned something today, and I welcome, of course, your thoughts and comments, and make sure to keep them empowering, because if you make any bash anybody, me or anyone in the comments, I'm going to delete your comment, okay? And you might be banned or blocked. So let's have a discussion, and let's keep it empowering. Let's keep it civil. And yeah, if you haven't yet subscribed to my channel, I appreciate it if you do. And I look forward to continuing to bring more information in this case. And as the developments happen in this case, I will let you know. And with that, stay safe, stay thriving. Remember to listen to your intuition, listen to your gut, and make sure to keep it empowering. Have a fabulous weekend, everyone. Bye.
Don't forget to like, subscribe, and hit the bell button for notifications. Thank you.